Hi, I'm David Cox, a local immigration attorney in St. Louis, Missouri. We're here at Blondie's in downtown St. Louis to cover what we call Lunch with a Lawyer, where you get to ask questions and I'll provide some answers. No attorney-client relationship is established by these answers that I'm about to provide to these questions, and if you have questions specific to your case in these areas, please see your own attorney. Well, there are a number of work-based visas that allow people with special skills and abilities to come to the United States at the request of an employer. To qualify for the kinds of outstanding and unusual skills that I think this person is asking about would probably require even greater skill and renown. For example, a world-famous violinist or sports figure. These people can qualify for particular visas to travel into the United States based on those qualifications. It doesn't sound like the qualifications being described here reach that level of world renown. So the next level after that is merely a specialty occupation visa. That requires a degree generally. You can do it based on an equivalency of experience if that's what the profession generally holds itself out to do to qualify people in that area. So depending on what the salon was doing and what the skill was that was required by the salon, if it is common to meet those skills and those requirements through experience as opposed to a college degree, you might be able to qualify that job as a specialty occupation and get a visa for a specialty occupation. It's actually called an H-1B visa. It is much easier, however, to qualify for those based on a college degree or the equivalent of a college degree in a foreign country. So I always recommend to employers that they work a job description that requires a degree and that the employees they want to hire have that requisite degree, and it's much easier to get a qualification. Here's the other caveat. There's a quota every year for the number of these specialty occupation visas that can be issued. So even if an employer has a qualified employee and a great job for them lined up, and they otherwise are able to take advantage of this visa, if the numbers are all used up for that year, they're going to have to wait till the next year. Right now, for example, the numbers were used up for this year back in June of 2012. So the next time it'll be possible to even apply for an H-1B visa, a specialty occupation visa, will be April of next year, April of 2013. Obviously better to start sooner rather than later because there is a process to preparing the application. What most H-1B employers are doing is hiring attorneys to help them with the process so that when April 1st comes up and the new quotas are available, they can file right away. And most people are applying in that manner. So they have the application all prepared. They've been doing it maybe 2 or 3 months in advance of that. And that's probably to most precisely answer your question, the period of time you would need to get an application ready to file in April of next year. So start at the beginning of the calendar year to get ready for an April filing. For that visa category, there are other visa categories, and that's something that comes up quite often, is people will ask questions all the time. I want to bring somebody here to the United States. Generally speaking, there are only 2 ways to do that. There's a family relationship basis for bringing someone. In other words, they're a brother or a sister, or your father or your mother, a child or a spouse. Other relationships don't qualify. Nephews and nieces don't qualify. Aunts and uncles don't qualify as close enough of a relation for you to be able to help bring them to this country if you are a permanent resident or a citizen. So that's the first category, family relations. The other category is employer-sponsored visas. They can be immigrant visas or non-immigrant visas, but you have to have an employer who will sponsor you. You have to have a qualified position. And quite often, employers actually have to vet those positions in the public marketplace here. And if any U.S. citizens who are qualified, citizens or permanent residents who are qualified, apply for those positions, they cannot offer the position to a foreign worker, obviously. So those are very difficult to do, and it is very difficult and I'm sure this isn't surprising to most people, for a U.S. employer to bring over, certainly permanently, an employee to work in the United States and get a green card. It's much easier to bring somebody temporarily for a few years at a time to fill a particular need, and even that is difficult. But those are the two ways that someone can come to the United States, either for a significant period of time or permanently, and that is through a family relation or an employer sponsor. And there aren't any other ways, with a few exceptions like asylum or some of these outstanding visas we were talking about earlier. Well, this has been Lunch with a Lawyer. I'm David Cox, immigration attorney in St. Louis, Missouri. If you're interested in submitting questions of your own to be answered, go to coxesq.us and select the Ask a Lawyer tab. You'll be able to fill out a form that presents your question to me for an answer. And again, you won't be able to rely on my answer because all of those answers provided through that mechanism, like the answers I provided in this video today, are not considered personal attorney-client advice. You would need to enter into an attorney-client relationship to get that kind of advice, and I would recommend you do that. We're going to be posting these videos regularly on coxesq.us, so check them out, visit us often, and we hope to be able to help you with your immigration problems.